Sam Funk of the Nashville Bar, and I represent the defendant appellant, Houston County. If I may reserve 5 minutes for rebuttal, please.
5 minutes, yes, sir.
Thank you, Your Honor. As the court is well aware, we've already been before this court once before in 2019, or the opinion's dated 2019, in this same case. And that's where I want to start, if it's okay with the court, to go back to this court's opinion from 2019. And there's 3 sections of that opinion I think that are of critical importance. The first is where the court describes sort of the underlying LOI and the mechanics of it. And essentially the court said, if Houston County closes on the transaction, that's to purchase the assets of the hospital, that it would then be obligated to pay back the money that Acute injected in the hospital. But if the closing doesn't happen in accordance to the letter of intent, Houston County would not be obligated for those financial obligations. Okay? And these are the same obligations that PCMC, if it's all right if I use the acronym, People's Choice Medical Center, the notes they had signed along the way as Acute Care injected money in the hospital. And those notes were signed, and there were a series of notes over the course of about 8 months or 9 months. The next step in the court's opinion is the court had said that the dispositive issue, okay, this is the key issue in the case, is concerning Acute Care's breach of contract claim is whether there's a genuine issue of genuine dispute of material fact that Houston County acted in good faith in negotiating an asset purchase agreement with PCMC by the deadline. And that was the issue we were here before. Judge Wolf, the trial judge, had granted us summary judgment, and Acute had said, well, wait a minute. If the closing didn't take place because of something you did or didn't do, then you can't use that as your out. And so this court said, okay, that's the dispositive issue. And on page 11 of this court's opinion, they said there is a dispute of fact. And the court remanded it. And essentially the court said there's a genuine issue of material fact concerning whether Houston County acted in good faith in negotiating the asset purchase agreement with PCMC and in closing on the purchase of the hospital by that deadline, either by refraining from conduct that would prevent it or hinder the occurrence of the condition precedent or by taking affirmative steps to cause the occurrence. So they reversed summary judgment, Your Honors, reversed summary judgment, sent the case back. And so the issue, presumably back before the trial court, is did we, or did the county, act in good faith or not? Was there some evidence of bad faith that we somehow did or didn't do something and prevented the closing from taking place? Many years later, Acute files a new motion for summary judgment. And in their new motion for summary judgment, they argue that, well, it's not really about that. It's about either one, once the due diligence period ended, that we were then obligated, the county was then obligated, no matter what, to reimburse them for these expenses. And then they also argued for the trial court that as a matter of law, okay, the terms had been reached on an asset purchase agreement between the county and PCMC. And we believe both of those are in error. And we believe they're hotly contested fact issues, particularly about whether or not an agreement was reached. Nevertheless, and obviously we opposed the motion, the trial court granted their motion, okay? And the trial court ruled as a matter of law that an agreement had been reached prior to December 31st of 2012, and that based on that agreement, we were forced to close. Again, we believe that is an error. Interestingly, neither Acute nor the trial court's opinion can explain exactly what the agreement was. The agreement was supposed to be purchasing assets and assuming certain liabilities. It's unclear which liabilities were in and which liabilities were out. The record's full of evidence that says we, the hospital, or excuse me, we, the county, were asking PCMC for a purchase price. And as the court's well aware, a purchase price can take many forms. One is cash. I could buy your business for $1 million. The second is I could buy your business and assume $1 million of liabilities. That would also be a $1 million purchase price. Here, the big dispute between the county and PCMC was which liabilities were included and which liabilities were not included.
If the county didn't know what the contractual terms were, why did the county commission on 2 occasions approve the sale without any further conditions?
You're referring to the resolutions, Your Honor?
Yes.
Yes, yes.
That authorized the mayor to execute the contract.
Yes, in all material specs. Perhaps that was a bad decision on their part, but the reality is PCMC never agreed to those terms. It takes 2 to ultimately reach a contract. We don't unilaterally have the opportunity. The county doesn't unilaterally have the right to close.
Didn't the closing ultimately occur?
A closing occurred, Your Honor, but it was a very different closing that was contemplated by the letter of intent.
And it was an asset purchase agreement, basically, with no assumption of liabilities.
And of certain assets, not all the assets. And again, I think that's a big fat question. In other words, did the deal that ultimately closed in 2013 outside of the 12/31 deadline, was that substantially the same deal, or was it even part of the deal that was contemplated by the LOI? I think that's an enormous fact question, because when you look at those, they are very different agreements, and they're very different deals.
Excuse me for interrupting, Counsel.
Absolutely.
The 2 resolutions, they were separate resolutions, not one that was passed on second reading, but 2 separate resolutions.
That's my understanding.
Were they identical in their language?
I don't know. I can't say if they were identical or not. I know they're very similar.
Very
I don't know
similar.
if I can't say exactly, but I believe they're very similar.
Okay, thank you.
So,
But in terms of factual disputes, there's no dispute here that the letter of intent says it's binding. It's a binding letter of intent.
right.
I understand the parties may have disagreements about to what extent it is binding. But then we know under paragraph 5 of the letter of intent, there are certain contingencies.
Correct.
Is there any factual dispute that the contingencies A through E, including the double B, were satisfied here? Or is there any dispute on those points?
Absolutely.
Okay.
Because
Which ones do I look to say, okay, those weren't satisfied?
The one you look to, I think, and there's also Section A of the contract, but I'm going to answer your question first, which is, if you look at I think this one doesn't change, it's D.
Okay.
Okay, and under D, it's the seller, that's People Choice Medical Center, complying with all its obligations pursuant to this agreement. Okay, under the agreement, the county is supposed to purchase the assets and assume certain liabilities. People's Choice Medical Center was insisting that we take all liabilities, okay, and indemnify them.
Well, so in the default world, though, with an asset sale, and I appreciate, if it's substantially all assets, a buyer runs the risk of maybe inadvertently assuming liabilities that they don't want to, but typically in an asset sale, you do not assume liabilities. It's not a given. There has to be some other. So really, the default state in a transaction such as this, when it's an asset sale, there wouldn't be any assumption of liabilities, would there?
Generally, no, but the
Yeah.
LOI specifically says.
And by the same
liabilities.
token, Houston County wouldn't be obligated in any sense to indemnify the hospital, the owner of the hospital. I can't remember all there's a lot of acronyms here.
Yes.
It's hard to keep them all straight. PCMC wouldn't have no obligation to. So really, the county could have said, you know what, screw the agreement. We don't have to, pardon the language, we don't need that because we don't have any legal obligation obligated, and we don't have any legal obligation right now to pay any liabilities that we didn't specifically agree to. We could just go through with the deal.
They actually couldn't, because under the LOI said, and this is the binding LOI on all parties, that we were assuming certain liabilities. I mean, that's the language that's in there.
Why wouldn't you look then at the term sheet that Acute Care put together about the list of expenses why wouldn't that be the determining factor? Why wouldn't that decide what liabilities were being assumed?
Well, I mean, the parties could have actually said that in the agreement. They didn't. The parties did not say that. The parties could have said, this is what it's going to be, and this is what it's not going to be. As an initial matter, we essentially had to assume or pay off the mortgage for the building. You can't get the building without that. So that was going to be part of it. But the question is, what other liabilities are in and what other liabilities are out?
And your client wanted no payables. And unless they agreed on it, unless someone else took another step, they wouldn't be liable for payables.
May I answer?
Yes, please.
Sure. But they had to get PCMC to sign the document. PCMC's got to countersign the sale agreement. We don't have an asset. We can't unilaterally create an asset sale agreement. We need them to sign and agree.
To agree to the transaction.
And they wouldn't, so we can't unilaterally impose our will upon them to say, okay, we're closing, but you're not. You get the same result where we are now.
All right, thank you, Mr.
Thank you.
Funk. We'll hear from you on rebuttal. Good afternoon.
Good afternoon, Your Honors. Taylor Askey of the Nashville Bar. I appreciate the opportunity to be before y'all again. Just to jump into it, to frame the issue that was at the trial court level that is being appealed, it was a motion for partial summary judgment that was just on the issue of whether or not Houston County breached the letter of intent. The issue of damages, the issue of computation of anything like that, not before the court.
The damages have been agreed upon.
Yes, Your Honor, that's correct. And there's no dispute that the LOI is a valid agreement, so that element 1 of a breach of contract claim stipulated to. The issue was just breach. And to point, Your Honors, back to your own opinion from 2019, when discussing the substance of the LOI, there has been extensive briefing on what the LOI says and who was to be obligated for what and under what circumstances. And all of that is agreed upon, that the LOI says what it says. But what the issue that was before the trial court was, how does the law apply to that LOI and what it says? And Your Honors noted in your order, it says, where a duty of one party to a contract is subject to the occurrence of a condition, the additional duty of good faith and fair dealing imposed on him may require some cooperation on his part, either by refraining from conduct that will prevent or hinder the occurrence of that condition, or by taking affirmative steps to cause its occurrence. Here is the important next language from Your Honors. Non-performance of that duty when performance is due is a breach. That's the breach that Acute Care asserted occurred here, was under the conditions that Your Honor was discussing with Mr. Funk earlier. Were those conditions satisfied? And if so, the duty to perform has occurred. It's triggered. And if performance thereafter is not, if you don't perform once it's due, that's the breach. So when we're looking at what the issue before the trial court was is there evidence in the record that these conditions were satisfied? And there was. And what happens there? The burden shifts to the defendant to point to specific record evidence that there is an issue of fact that could lead a rational trier of fact to find in the non-movement's favor. The only condition that has been challenged here is the hospital's failure to, I believe in the brief they said they wouldn't negotiate with us on the liabilities until after the expiration of the letter of intent. There was no discussion between the parties. They wanted us to assume all the liabilities and indemnify them. If you look at what the record we've cited in our brief to what is described as the no liabilities LOI, that is a letter of intent that was dated October 26th of 2012, where the hospital and the county, separate and apart from Acute Care, agreed, and this language is cited in our brief, that no liabilities were going to be assumed, that the hospital was going to indemnify the county for any liabilities. So the suggestion that there was no negotiation between the county and the hospital as to what liabilities would be assumed is wholly undermined by the record. And I point you to that October 26th date for a specific reason. Those resolutions that were discussed were passed in September of 2012 and in October of 2012. To Your Honor's question about is the language the same, virtually, I can't say every article and the A is the same. In substance, they are the same. They directed the mayor to execute, acknowledge, and deliver the signed APA and memorialize that contract. Now, the issue of purchase price came up too. Well, we didn't know what the purchase price was. Taking you back to that October 2012 timeline, no liabilities LOI, resolution from the county. There's emails in the record from Acute or Houston County's own attorneys to the USDA where they're saying, we know what the purchase price is. We don't have a specific number because we don't have a closing date set, but we're ready to process this for closing. What do we need to do? In response to that, the USDA responded and said, well, I see the purchase price is blank in this approved APA here. It's not filled in. Do y'all have a purchase price? To which the attorney for Houston County said, yes, it's going to be the amount needed to retire the debt, the mortgage debt on the property. The seller is getting no cash. So to answer your question, the purchase price will be that. We just can't calculate it because of the date. That's entirely consistent with what the LOI said as well. There wasn't a question as to what the purchase price was supposed to be. If you look at the language of the LOI, and this is at page 20 of appellant's brief, it says, the consideration for the purchase shall be the assumption or payment of seller's existing mortgage debt on the assets and the assumption of any other liabilities specifically set forth in an asset purchase agreement. That's entirely consistent across the board. So if we're looking at...
Well, isn't any other liabilities an uncertainty?
It could be whatever is to be included there. And to Your Honor's point there, if you look at the no liabilities LOI, where it says they're not going to assume any other liabilities, that's contemporaneous with these negotiations and falls within the due diligence period of the LOI. It lines up exactly. The assumption of any other liabilities does not assume that some liabilities are to be assumed. There just could be some. Ultimately, there weren't any. When the closing ultimately occurred in March of 2013, no liabilities were assumed. Exactly the same as the no liabilities LOI in 2012. And to put a bow on it, if you look at the closing memorandum, the documents that the county had to authorize to finally sign on the dotted line, the resolution that they relied upon that said this deal that is now being argued was a completely separate deal, separate and apart from the letter of intent that's at issue here. The resolution was from September of 2012. It was the one that was passed during the due diligence period. They did not go through another process to approve another deal. They did not go back and say, okay, this LOI thing didn't work out, we've got to start over. They relied on the approvals that they got during the due diligence period and during the time during which my client was funding and operating and managing the hospital.
During the 90s, there were these raft of cases where courts were enforcing transactions, mostly loans, I think, on letters of intent. And as a result, the bar reacted by adding this language to all these letters of intent saying, no binding agreement until reflected in it. I can't remember the language anymore because I'm too old and that happened 3 decades ago now, I'm realizing. But, no binding agreement until the terms of the definitive agreement have been reached, which isn't here. What I'm curious, but those happen, as I recall, mostly in loan situations. That's a vastly different situation than asset acquisition, substantially all asset. Are you aware of any cases where a court has enforced a asset transaction just based on a letter of intent? I'm assuming there's not, because you would have been all over that in the brief, I'm assuming.
I'm not aware of a case that enforces the asset purchase.
This, you'd be asking for the first time a court to affirm coming through on a asset purchase transaction based on a letter of intent, a two-page letter of intent.
I would push back against that, not because I disagree with the premise, but because I think it's a little bit different and nuanced. What we are trying to enforce here is the breach of the duty to close on an asset purchase agreement. The damages for which have been stipulated to, which was going to be the trial. What we want enforced is, and what the trial court correctly enforced is, on this binding letter of intent, if you read the very first sentence, it says, this letter of intent, this binding letter of intent sets forth the material terms upon which the hospital will buy the assets of the hospital. And it set forth certain contingencies and how that might go about. And during the life of the letter of intent, my client was funding the hospital's expenses. And to go back in time a little bit, and I would point to, in a loving way towards my client, the law in Tennessee is contracts don't have to be a model of clarity to be enforceable. This one was drafted in a more or less financial crisis within the county. The hospital was failing. They were missing payroll. It was the largest employer in the county.
Third largest.
Third largest, yes, Your Honor, thank you. Third largest employer in the county, and they were trying to get a deal done to save this hospital. Everybody came together, and the letter of intent was the framework by which they were going to endeavor to do so. Under that letter of intent, the closing was the final act. But in order for that to happen, certain things had to be met. My client was infusing money the entire time. Once all of the conditions were met for the closing, that is what the closing is what triggered my client to get reimbursed. I think that, and I would submit to Your Honors, that enforcing a specific APA is collateral to enforcing the obligations of the LOI to reimburse that would have been the ultimate result of that closing.
Your action is not for specific performance of the asset purchase. It's for specific performance of the LOI that if your client operates the hospital and advances these monies, then based upon this condition, you'll pay our promissory notes.
Correct, Your Honor, because as Your Honors noted in the first opinion, failing to perform when performance is due operates as a waiver of the condition. The reason that my client has not been reimbursed by the county is because the county's claiming that condition never occurred. But why didn't it occur? It was supposed to, because all of the contingencies to trigger that occurring happened. And so if we're looking at what it is that acute care is asking for, it is the waiver of the condition precedent that Houston County wants to use as a shield to its obligation to reimburse us. We're not seeking any damages related to management fees. We're not seeking any damages related to the ownership of the hospital. We weren't going to do it. This case is exclusively about whether or not, once the contingencies were met, whether or not the county can hide behind a condition precedent that has been waived now to avoid reimbursing us.
When the resolution authorizing the asset purchase agreement, county's resolution authorizing the initial asset purchase agreement, was it asset purchase agreement plus all the schedules, the whole shebang, or was it just the terms of the asset purchase agreement?
Could you ask that?
So when the county resolution authorized the execution of an asset purchase agreement, the asset purchase agreement approved, did it include just the agreement itself, or did it include the agreement and the schedules?
I would hate to misstate. I believe it was the full contract because there were blanks only for the purchase price.
Okay.
And
also all these things have tons of schedules attached. Those were attached to and approved as well?
everything that was before the county was approved.
Okay.
We were not a part.
May not include schedules.
Yes, we were not a
so
party
we just have
to
to
that.
look and see. So I just want to sort of play this out, how the law should work, or really how this deal would have worked. Let's say the county then took that agreement, was approved, presented it to PCMC, and they said, nah, I'm not signing that, not signing it. What happens under this deal in that circumstance?
If you look at the resolutions, there's language towards the end that say you're authorized, directed, and go sign it. But there's also language in there that says there can be changes to this agreement, and you're authorized to make those changes as well in order to consummate the deal. And that's why I focus on the closing memorandum that cites to that resolution, because even if there are changes to it, it's the same deal. They just didn't do it before the expiration of the due diligence.
Well, but the deal that actually went through, though, wasn't quite the same deal, was it? I mean, it just involved the hospital property.
It certainly changed. It certainly changed in terms of what they were going to be acquiring. They did not acquire the
number,
critical
the
access.
license numbers or anything of
Correct.
that nature.
They did not do that.
Which is where a lot of the value in this transaction was it not?
Our client certainly thought in order to save the hospital, they would need to retain that critical access value number.
And then they had some sort of special arrangement for Medicare or Medicaid in this instance?
Yes.
So the county didn't get that either?
They did not. But that's separate and apart. That deal is separate and apart from whether or not the conditions of the LOI have been met. And my client's right to reimbursement is not tied to whether or not PCMC and Houston County can reach a specific asset calculation or whatever they wanted to. It's not listed as one of the conditions in the contract. It is, if we don't cancel the LOI before the expiration of the due diligence period and all of these conditions are met, we're entitled to be reimbursed. You're supposed to close on the hospital.
And that includes both pre- and post-closing expenses that were advanced? Or just post-closing?
Pre-closing.
Just, okay, pre.
Because it was during the negotiation of this, that was when we were funding the operation of the hospital, and that's why those promissory notes were signed to say this is how much money we've expended every couple months, here's another one. And if you look at the LOI, the purpose of those promissory notes were to memorialize the amounts expended. And so on closing, whatever we had spent up to the closing, that's due back. If we spent something more afterwards, that's on us.
And you hinted at it a moment ago, but part of your argument is that the county did not cancel the contract, the LOI, before the closing date, and that obligated them. Is that your argument?
The twofold, Your Honor. Under the LOI, the language gives acute care the right to terminate the agreement. The due diligence period was for acute care to go in and see, is this going to be a viable arrangement? If they did not cancel the contract, Houston County's obligation to close on the hospital was permanent, save for the non-occurrence of these conditions. That was the only escape hatch they had, which is why you go back to the record and say, is there proof in the record that these contingencies did or did not occur? And under the summary judgment standard, it's Houston County's burden, once we've come forward with proof, to point to specific evidence in the record, taking the record as a whole, that one of those conditions, there's a question of fact as to one of those did not occur. And there's no dispute before you that
All right.
that's not what happened.
Thank you very much.
Thank you very much, Your Honor.
Okay. Thank you, Mr. Askew. Mr. Funk?
Thank you, Your Honor. Let me start with sort of where we just finished, and that was under the LOI. The LOI provided for as originally drafted, provided for a 30-day due diligence period. But under the LOI, two things could happen. Number one, Acute could cancel the transaction within the 30-day period. However, if you get to the end of the due diligence period, at the end of the 30 days, the transaction was deemed canceled if they didn't waive their right to cancel. And what happens is there's two amendments to the LOI. The original date, I believe, would have been March 29th. It was the original deadline. The amendment was then executed on 4/17, and that extended the due diligence period to 7/31. There was a second amendment to the LOI. It was executed on 7/6, that's July 6th, and that's what took us to 12/31. But this idea that the only escape hatch was Acute canceling it is not correct. If you get to the end of the due diligence period and they haven't canceled, the agreement cancels itself, and that's pursuant to Section 2, excuse me, it's canceled if they don't waive that provision. And that's of critical importance. Here, no closing occurred before the end of 12/31. That's critical because at that point, the agreement, the transaction is canceled per the LOI. Now, Mr. Askew referred to something that he calls the no liabilities LOI. This is the later LOI that's executed in October of 2012. But frankly, Your Honor, that's a misnomer. That's not a correct way to refer to that document. If Your Honor will look at the October 26th LOI, okay, it's got many key differences between that and the original LOI. The original LOI, as Judge McBurr pointed out, was binding. This is actually a non-binding document. It specifically says, as you see in a lot of LOIs these days, it's non-binding. The second thing it says is that the purchase price, okay, the assets listed agreed to in the purchase price, it says substantially all the assets, but it says specifically excluding the, quote, excluded assets. So it's not even going to be all the assets. And as Your Honor pointed out, there are things like the Medicare license number, which is the critical access, that ultimately gets excluded. But even which assets are included are up for negotiation. And the price is up for negotiation. And then lastly, again, you heard it called the no liabilities LOI. This is what the document says at Section 4. Quote, except as the parties may agree in the agreement, buyer will assume and will not assume any liabilities, except as to be agreed. So even under the October 26 LOI, which assets are in or out is wildly up in the air. Which liabilities are in or out is up in the air.
What gets me about this transaction, though, at the state that the parties were in, Houston County was in a position where they could have presented PCMC anything they wanted, and they really had no choice but to sign it. So to me, you know, some of these concerns about, well, we're worried about, you know, what liabilities we might inadvertently assume or something like that, really easy to take care of. You present the most onerous asset purchase agreement you can come up with to PCMC. What are they going to do? Oh, we're not signing that. Well, then the hospital fails and they're on the hook for that plus the mortgage. I mean, I don't know, that argument just rings a little hollow to me based on where the hospital was in this point, because the county could have really forced them to do anything.
One would think. However, that's not what happened. We presented it to them, and Mr. Schumacher, who's the head of PCMC, who's been indicted for Medicare fraud, okay, he says, no, I'm not going to sign this. I want you to take all of the liabilities, and I want you to indemnify me. And at this point, all we know is he's been indicted for Medicare fraud for another hospital, I believe in Mississippi. Nobody knew exactly what had happened in this hospital, and so the county said, there's no way in a million years we're going to indemnify you. It was only until his wife got involved, or his ex-wife, excuse me, became the ultimate power of attorney. She signs the October LOI, and she's the one who ultimately comes to her senses, as you said, and says, oh, all right, this is crazy. We're not going to get indemnity from the county. Therefore, we'll agree to sign this new contract. But that doesn't happen until well after December 31st. And it is a different agreement. And by the terms of the original LOI, once the due diligence period passes, the, quote, transaction's canceled, and at that point, there is no fee owed.
All right.
I know my time's up.
Thank you, Mr. Funk. Thank you, Mr. Askew, for your arguments. We'll take this matter under advisement.
Thank you, Your Honors. Probably goes without saying, may we be excused?
Certainly.
Thank you. As much as I would like to